So the purpose of the Article 5 call to the states was ostensibly to decentralize the federal government. It was pushed by agrarians, pushed by Jeffersonians to have the states, have the people an opportunity, to give them an opportunity to sometimes step in and amend the Constitution whenever the federal legislature wasn't listening. Now keep that in mind, whenever it wasn't listening. They were that afraid of the federal legislature, that afraid that one day this system might not work the way they supposed. So they put this amendment, or this Article 5 amendment process in the Constitution just for that reason. That's a fact. That's not what-if thinking. That's not fear-mongering. That's not alarmism. It was placed in there by people that I admire greatly, like Thomas Jefferson and others, or at least his mindset, his anti-federalist concepts, that mean very much to me. So the purpose of the Article Amendment process given to the states makes good sense to me. That's a fact. Created by anti-central authority individuals, created by pro-state sovereignty individuals. So from that standpoint, we recognize Article 5's historical underpinning. It's very sound. That goes to my second point. We're arguing fact here, not what-ifs. I heard someone argue the other day they disagreed with the concept of an Article 5 convention because they were so-called strict constructionist or strict constitutionalist. Different words, semantics perhaps, but I think I see their point. But how much more strictly can one construe the Constitution than to point specifically to language therein and try to utilize it to correct it? That's what Article 5 is. The true strict constructionist here can read Article 5 in the Constitution and can apply it as we see fit, pursuant to the law. That is strict constructionism. How can you accuse us of otherwise? We are reading from the document itself, word for word. So I think the argument that somehow I'm a strict constitutionalist or a strict constructionist and therefore I don't support an Article 5 convention kind of rings hollow when you think about the whole point of Article 5 is based on the clear and strict language of the Constitution itself. So that's another fact. Let's talk about some other things. Your federal government right now is not listening. Hasn't listened in a long, long time. We have evidence of that. These are facts, not what-ifs. We know the debt is increasing at an alarming rate. We know that despite the fact that the parties have exchanged control over the federal government, that regardless of which party is in power, the debt continues to increase. Even though Republicans had control over the federal government over the last 2 years roughly, we have increased the debt by more than $2 trillion. Debt is a problem. It's a real issue. It's not going away. The great majority of this debt is spent on extra constitutional measures. Extra constitutional measures. And what that means is a lot of this spending is clearly unconstitutional. Let's stop right there and talk about facts, not what-ifs. It is a fact that your federal government is exercising outside of its constitutional power. It is a fact that the document intended to limit the government's power is no longer limiting the government's power. That is a fact. If that is the case, then I would like to ask the opponents of Article 5 precisely which Constitution are you defending? A Constitution that's basically been torn apart by the federal courts, a Constitution that's been amended 27 times, a Constitution that no one appears to be reading anymore, a Constitution that we swear an oath to defend and protect and then ignore it the second we're elected. Debt, a loss of civil liberties, whether it's the Patriot Act or other things, a Constitution that no one can comprehend evidently because it's not controlling the federal government, a Constitution that's allowed the Federal Registry to grow to 3.2 million pages, all of which have equal force of law, none of which is terribly constitutional. A Constitution that has been perverted by the federal court system, that's enriched the federal court system beyond measure, empowered them beyond measure. These are facts, not what-ifs. This is the present state of our constitutional republic. We have lost control. The founders were smart enough to envision this time could come. And they knew that Congress itself would never agree to curtail its own power. So they gave the states a chance, one last chance to force Congress to curtail its power. That's what we're doing with an Article 5 convention. Now, those that claim that somehow it could be problematic, I would only suggest that inaction itself at this stage is our greatest enemy. Inaction. Inaction. Every year the government grows. Every year the debt grows. And the government is on auto drive. It's on auto drive. If we take no action, it grows. If we take no action, more civil liberties are lost. If we take no action, more wars without congressional authorization will be declared. If we take no action, more state sovereignty is lost. I'll give you an example of that. Does the 10th Amendment have any power anymore at all? The 9th at all? Look, inaction at this stage in our country's history will lead us down a path from which we cannot recover. Inaction. Now, here are the what-ifs. They're not arguments, they're what-ifs. And every argument I've seen online to oppose the Article 5 process is always about what-ifs. It reminds me of an old story, if you've ever heard or read Winnie the Pooh. My kids love Winnie the Pooh. You might remember there's a scene where Pooh and Piglet are sitting under a big tree. And Piglet was always worrying. Piglet had anxiety. You remember Piglet was always upset about everything. And Piglet said, "Oh, Pooh, supposing this tree were to fall on us." Now think about that. That's what-if thinking. Supposing this tree were to fall on us. And Pooh said, "Supposing it didn't." Clever Pooh pointed out that what-if thinking isn't always accurate, almost never is. And in fact, if you're going to dance that dance, what-if thinking cuts both ways. They argue that the Article 5 Convention would be a dangerous slope, that things could spin out of control. That's a what-if comment. They have no evidence to suggest that could happen. It's a what-if. It's speculation. But let's accept their argument for the sake of fact for a moment and assume that it could spin out of control. There are roadblocks by which we can protect ourselves in that regard. The most obvious is the fact that any amendment would have to be ratified by 3/4 of the states. Now let that sink through in your mind for a minute. 3/4 of the states. What is that, 38? Something like that, 37, 38? Amending the Constitution is incredibly difficult. It's supposed to be incredibly difficult. Now, what if I told you right now that Republicans controlled both houses, that is, the state and the Senate, in 32 of those states? And you're really going to make the argument that somehow this convention could go completely out of control and that they're going to start doing away with our basic civil liberties. That's what-if thinking. It's fear-mongering. Based on the current numbers, with 32 state legislatures controlled solely by the Republican Party, that nobody's going to abolish the Second Amendment. Nobody's going to get rid of the Electoral College. Come on, folks. That's fear-mongering. It's what-if thinking. That's the best protection that we have to make sure there can't be a runaway convention. And I think it was a very successful protection considering 3/4 of the states would have to ratify. The second argument they made, they say, well, who chooses the delegates? What if all the delegates chosen are not good delegates? That's a good argument, but it's based on what-if speculation. In other words, inadmissible in court, not really an argument at all. Let me spin the question. What if the delegates chosen are good delegates? What if the delegates chosen are all like Justice Scalia? Now, I know what you're saying. That's not likely. You're exactly right. It's not likely. But neither is the other. The delegates chosen will represent a cross-embodiment of the people of this country, at least as presently configured, many of which will be establishment individuals. If they go to the convention, they will have a chance to correct or repair problems with our Constitution, particularly when it comes to spending, and to try to create a more perfect union. If they fail in that endeavor, we know who they are. When they lie at that endeavor, the whole world will watch. It will be one of the greatest educational moments of our time to remind us about what a Constitution is and what a Constitution is not. And if they do something that's completely out of the ordinary, we will reject it. And if we don't reject it, we'll know then that these people aren't the type of people we can work with, right? Another argument is that the federal government ignores the present Constitution. That's true. That's true. And then they argue in the same breath, and because of that, amending it would be a waste of time. Perhaps. But if the federal government's already ignoring the present Constitution, then which Constitution are you protecting? A blank piece of paper? That's what the status quo is at this stage. That's what inaction gets us at this stage. That's another what-if argument I just don't find convincing. Other people say there's no way to limit a convention. Anything can be brought up. Well, yes and no. There are legal scholars on both sides of the equation. Some say the call can be limited. Some say it cannot be. But Mississippi and other states certainly could withdraw, could we not, if the call exceeded the balanced budget amendment. Other states could withdraw. If that's the case, then obviously there's no chance that state could ever ratify something that went out of control. Yeah, there may not be a way to limit a convention. That's subject to some serious research. But if the case of the convention gets too widespread and too diverse, it makes it that much easier to defeat when you have to still get 3/4 of the states to ratify. It's more thinking that's based on what-if thinking as opposed to fact. Another argument they seem to make, the ones that oppose it, they say the founders didn't want this. That's the strangest argument of all, because the founders just placed this specifically in the Constitution by unanimous vote. Of course the founders wanted it. Then they cite Madison. And Madison had written some language that indicated he did not want to re-enter a constitutional convention. That is accurate, but it doesn't apply to today's context. You can't use quotes from 200 plus years ago, take them out of context, and think they mean the same thing in 2019. When Madison left the Constitutional Convention, they had been through an awful lot of work. It was very heated, it was very delicate, and it could have easily just fallen apart. Of course, 2 years later, he didn't want to re-enter the convention. That would be silly. They had just completed the convention. They used to have these major divisions in the country between the French and the English, between the Federalist and the Anti-Federalist. Of course, in 1780s or 1790s, he didn't want to re-enter the convention. That has no real applicability on 2019, where we should at least take some effort. One other argument seems to indicate that this convention could limit state sovereignty. Nothing could be further from the truth. It was created solely to protect state sovereignty. It was created by the Jeffersonians to make sure state sovereignty was protected.
The Senate is back in order.
All right.